The Honorable Chief Justice and Associate Justices of the Supreme Court of North Carolina. Oh yes, oh yes, oh yes, the Supreme Court of North Carolina has resumed sitting for the dispatch of business. God save the state and this honorable court.
Good morning, everyone. I want to note that Justice Berger is recused on this case. This case is Lauziere versus Stanley Martin Communities, LLC et al. That being said, we'll hear from the appellant.
Thank you. Chief Justice Newby, Associate Justices, may it please the court. My name is Mallory Ladeka with Lewis and Roberts. I'm appearing along with my co-counsel Brian Cantley, and we represent the defendant's appellants in this claim. Respectfully, we would like to reserve 5 minutes of our time for rebuttal. On May 22, 2018, the full commission unanimously dismissed the appellee's workers' compensation claim with prejudice for failure to prosecute, making numerous findings of fact to support its conclusions of law that all three prongs of the Lee versus Roses test for a dismissal of a claim for failure to prosecute had been met. On appeal by the appellee, the Court of Appeals majority, however, reversed that dismissal decision, focusing on three findings of fact it claimed were unsupported by the evidence. It has been confirmed by this court that the full commission is the fact-finding authority, and the Court of Appeals was required to uphold the findings of fact of the full commission if there was any competent evidence to support them. Yet in reversing the full commission's dismissal, the Court of Appeals substituted its judgment for that of the full commission by improperly reweighing the evidence related to the Lee dismissal factors. As competent evidence exists to support the full commission's findings of fact, which in turn support their conclusions of law, and given that the Court of Appeals failed to apply the appropriate and deferential standard of review with regard to those findings and conclusions, we respectfully request that this court reverse the Court of Appeals majority and reinstate the full commission's dismissal of the appellee's claim with prejudice for failure to prosecute.
Ms. Ladeka, I'm sorry to interrupt you, but as I understand the Court of Appeals opinions, there's a majority and a concurring and dissenting in part opinion, both of which would not uphold all of the findings, one of which would, the majority reverses and remands for further proceeding, and the dissent would vacate and remand. Can you articulate how you would understand the difference between the mandate of these two opinions and how that would work on remand?
Yes, Your Honor. Our understanding is that the Court of Appeals majority would have reversed the dismissal and allowed the appellee's claim to proceed forward on a decision with regard to compensability of the merits. And we would contend that that would be an improper result, given that the full commission was the fact-finding authority, and the Court of Appeals should have deferred to its judgment with regard to the findings when there was competent evidence to support them, which there was. In the alternative, however, given the inherent task of the full commission to be that fact-finding authority, and as Your Honor correctly pointed out, Justice Hudson, we would respectfully request that if an upholding of the dismissal of the claim were not proper by this court, that this court rule in line with Judge Dillon's dissenting opinion to vacate the decision back to the full commission. Judge Dillon's dissenting opinion, as my co-counsel will discuss in more detail, found that there was only one portion of conclusion of law 5 that he agreed with the majority may not have been supported by competent evidence. But in his opinion, even without that finding that the majority and Judge Dillon thought may not have been supported by competent evidence, Judge Dillon did not think it would have been an abuse of discretion, given the inherent fact-finding authority of the full commission, for the dismissal to still be proper, given the other findings of fact which were supported by competent evidence. So we would contend and respectfully request that this court reinstate the dismissal decision, given that there's competent evidence to support the findings and the conclusions of law with regard to the dismissal. But in the alternative, and at the very least, given the fact-finding authority of the full commission, we respectfully ask this court to rule in line with Judge Dillon's opinion, vacate the claim to the full commission, and allow them to determine if sufficient evidence existed to uphold the dismissal, even without that portion of conclusion of law 5 that may not have been supported by competent evidence.
I don't want to get, go ahead, Justice Hudson.
I was just going to follow up with, the reason I was asking that is because of the sentences at the bottom of page 12 and top of page 13 of the majority opinion, citing to Chambers, in the parenthetical says that if the conclusions of the commission are based on a deficiency of evidence or misapprehension of law, the case should be remanded so the evidence may be considered in its true legal light. And so that made me wonder whether what the majority was intending is that the dismissal be reconsidered and additional findings entered, because then the ultimate conclusion is, you know, remanded for proceedings consistent with this opinion, whatever that means.
I understand the confusion, Your Honor, and I think that Judge Dillon actually addressed that in a footnote in his dissent as well. I will turn Your Honors to the very first page of Judge Dillon's dissenting opinion. In footnote 2, he gives an analysis of the fact that the words reversed and remanded are sometimes used interchangeably, and so it did appear slightly confusing as to whether the majority's opinion intended to reverse and kick it back down to the full commission for a determination of whether the remaining findings, which it may have thought were supported by competent evidence, would uphold the dismissal, which is essentially what Judge Dillon did. However, our reading of the opinion was essentially, and I think Judge Dillon read it this way as well, that the majority opinion intended to reverse the dismissal in full and allow the case to go back to the full commission only so that a compensability on the merits of the claim could move forward, meaning that the dismissal would not have been proper. That was our understanding. But in any event, we would agree with Judge Dillon.
I had understood the order to allow the imposition of lesser standard, of lesser sanctions. Is that not the order, the decision of the majority of the Court of Appeals? I apologize for misspeaking. Do you read the Court of Appeals majority opinion as prohibiting any sanctions?
Yes, Your Honor. Our reading of the majority opinion and a reading of Judge Dillon's dissenting opinion does appear to indicate that the majority intended to indicate that the dismissal in itself should be reversed. And as I mentioned, the claim kicked back down so that a compensability determination on the merits could be held. We did not read the majority opinion to indicate that it was being sent back down to the full commission for a determination of whether lesser sanctions would be appropriate. And part of that.
What do you make of the sentence that starts on the 5th line of page 12 of the, and I don't want to get us too far off course here, but on page 12 in the 5th line, there's a sentence that reads, quote, without the necessary evidence or findings, other less permanent sanctions remained available, such as civil contempt. And then at the very end of the opinion, it says that the order of dismissal is reversed, in this case remanded to the Industrial Commission for proceedings consistent with this opinion.
I do see where it is referenced there in the majority, Your Honor. However, conclusion of Law 5 actually goes into more detail, as my co-counsel will further discuss, with regard to how sanctions should be considered in claims where we're looking at a dismissal for failure to prosecute. And under the third prong,
I'm not wanting, I'll let you go there in a second, but I want to make sure I understand what you think the scope of the majority opinion is. Is it your contention that the majority opinion prohibits the commission on remand from imposing any sanction upon the plaintiff at all?
Yes, Your Honor. We read the majority opinion to say that this claim was being sent back down to the full commission for no further consideration with regard to the dismissal or sanctions, but to send it back down to allow the Industrial Commission to permit the case for proceeding on the merits.
Okay, now one other question, and then I'll let you get to where you want to go. To follow up on Justice Hudson's original question, you in your brief and today have urged us to uphold the original order. Given the scope of the review that this court exercises, how do we have the authority to do that consistently with the rules of appellate procedure, given that the dissent, as Justice Hudson points out, also called for remand?
We would contend that Judge Dillon's dissent indicates that there was sufficient evidence to uphold the dismissal, even if there was a finding of fact that may not have been supported by competent evidence. And we would contend,
even though he didn't say that?
He said in his dissenting opinion that in his opinion, there was competent evidence to support the findings that would have upheld the dismissal, even if they took out.
Does the commission, in order for a dismissal to be upheld, don't you doesn't two things have to happen? First, the commission makes the necessary findings, and secondly, that their findings have adequate evidentiary support. I had understood him to say that the commission could have made the necessary findings in some instances, but didn't. And that's why he was calling for a remand.
Respectfully, Your Honor, we read the dissent decision to say that the competent evidence may not have existed with regard to one portion of a finding in conclusion of Law 5. Conclusion of Law 5, as my co-counsel will discuss, was actually treated as a finding of fact for review purposes because it contained various factual findings. And so our contention would be that Judge Dillon's opinion was that there was sufficient findings of fact that the commission, in its discretion and given the competent evidence that supported those findings, could have dismissed the claim. But because on their review there was a portion of a finding of fact which he agreed in the majority may not have been supported by competent evidence, his vote was to vacate. And as we indicated, we think that a vacating of the claim to the full commission to allow them to exercise that inherent right as fact-finding authority is more than appropriate in this claim.
Okay,
So let me follow up on that. If his vote in the dissenting opinion is to vacate and remand, that would mean that there would be no order, and that the full commission would have to start again, I suppose, on making findings and conclusions on these issues. Is that how you would interpret that?
We wouldn't, no, Your Honor, respectfully, we would interpret it as the full commission would get the evidence as it existed in front of the first full commission panel, would review the first full commission's findings and confirm that they were appropriately supported by competent evidence, and that those findings likewise supported the conclusion that the dismissal with prejudice for failure to prosecute would have been appropriate. It was not our reading that it would be new evidence or additional evidence or new findings, but that it would have reviewed the evidence for the findings that were made by the full commission to ensure that those findings which were supported were sufficient to allow the dismissal with prejudice.
So is it your interpretation of it then that some portion of the full commission's opinion would be left intact if we agreed with the dissenting opinion here?
Yes, Your Honor. If the claim were to be sent back down to the full commission for them to review whether even taking out that portion of the finding that the dissent and the majority determined may not have been supported by competent evidence, that the full commission could still look at the remaining evidence, the remaining findings, and in their discretion continue the dismissal with prejudice based on those supported findings. And okay. I do see that. I'm sorry, was there another question? I didn't mean to interrupt. Thank you, Your Honor. So again, we agree that a vacating of the claim to the Industrial Commission as the fact-finding authority to consider whether the dismissal would have been appropriate is a proper resolution as Judge Dillon recommended. And the reason that this is a proper resolution is because the findings that relate to the second and third prong of the Lee versus Roses test, which relates to the prejudice to the defendants as a result of the plaintiff's failure to prosecute, and the reason why sanctions short of dismissal would not suffice, are supported by the findings of fact and the competent evidence of record. And I'm just going to briefly touch on finding of fact 24 and then allow my co-counsel to jump to finding of fact 25 and conclusion of Law 5, which Justice Ervin, I think, will go a little bit more to your questions about the consideration of sanctions. But finding of fact 24 looked to the prejudice to the appellants in this case as a result of the failure to prosecute because of a deprived opportunity to investigate the claim and to direct medical care. And this was all based in the fact that the appellee refused to comply with an order compelling discovery, which required her to provide pre-injury medical records related to prior medical treatment for the exact same type of injuries she was claiming relate to this claim. Evidence of that can be found in the fact that the appellants were unable to obtain, despite their numerous requests and the Industrial Commission's order to compel discovery, a full set of pre-alleged injury and post-alleged injury medical records, which would have allowed them the opportunity to make a liability determination and possibly direct medical care with a view to minimizing the seriousness of the injury or possibly mitigate future damages as well as lessen the period of the appellee's disability.
Let me ask you about that. I'm confused about that a little bit because my reading of the statute is that 9725.6 subsection C specifically provides that an employer, and I'm reading here, is entitled without the express authorization of the employee to obtain the employee's medical records containing relevant medical information from the employee's health providers. And I always understood that to mean that as is common practice, the employer is able to obtain medical records of the employee without seeking a release, and that they do it all the time.
Yes, Your Honor, that is an option available with regard to medical providers of which we are aware. But due to the appellee's outright refusal to provide us with a full list of the names of medical providers with whom she treated primarily for pre-alleged injury medical conditions that pre-existed the date of injury and for which she received what appears to have been significant treatment, including surgery, we were unable to undertake that investigation and have a complete pre-injury medical file, which would have allowed us to make that liability determination.
Even with the ability to obtain medical records with no authorization from the plaintiff.
Yes, Your Honor, because the Lee factor does not require a complete loss of an inability to obtain any medical records. It requires a loss of a meaningful opportunity to investigate the claim and make a liability determination with a view towards potentially accepting liability for the claim, which would have allowed the defendants to come in and direct medical care. And because the appellee refused and outright objected to providing us with information related to those prior medical records in full, we do admit that there was some medical information that we were able to obtain, but we were not able to complete the investigation in a substantial part because of her refusal to provide us with that pre-injury medical information. Even with the ability under that statute to write the doctors and request medical records, we would not have been able to do so without that actual information, which she refused to give us. And that was in direct violation of an order to compel discovery with regard to those pre-injury medical records. Given the refusal to provide those pre-injury medical records in direct violation of an order to compel discovery, and given that that delay impeded us from making a liability determination with a view towards affecting future treatment or mitigating costs, we would contend that sufficient evidence existed to support finding of fact 24, which is one of the findings upon which the Court of Appeals majority relied.
Let me ask you one other thing, and I'm not as versed in commission procedure as Justice Hudson is. Are there separate provisions in the statutes or the commission's rules authorizing sanctions for failure to make discovery separate and apart from rules or statutes authorizing dismissal for failure to prosecute?
Yes, there is a portion of the Act that allows the Commission and its inherent authority to assess sanctions as a result of a failure to comply with orders to compel discovery. But Your Honor,
why isn't the real remedy for your problem here sanctions for failing to make discovery as compared to sanctions for failure to prosecute?
we would contend that sanctions have previously been assessed in some form. The Industrial Commission issued an order to compel discovery, which the appellee violated. We provided various warnings and instructions to the appellee that if she did not provide us with that requested, relevant, ordered pre-injury medical information, that we would be unable to proceed with a hearing on the merits. And her claim was removed from the hearing docket pending her compliance with an order compelling discovery. So while it is not required, as my co-counsel will discuss in further detail, to actually assess prior sanctions before assessing a dismissal with prejudice, the Industrial Commission must only consider those sanctions, which we would contend they did. And those sanctions would have been entirely futile given the appellee's actions thus far in this claim.
Does the Commission have the authority to dismiss the plaintiff's claim for failure to make discovery?
Yes, Your Honor. The Industrial Commission has inherent judicial authority according to the Lee case to dismiss the appellee's claim for failure to prosecute. And I'd like to turn it over now to my co-counsel to discuss.
No, I'm not talking about a dismissal for failure to prosecute. I'm talking about, do they have the authority to dismiss the plaintiff's claim if there is a violation of the plaintiff's obligation to provide discovery?
Yes, the Industrial Commission rules indicates that the Industrial Commission has inherent authority to assess sanctions, and it does not preclude them from assessing a dismissal for violation of Industrial Commission orders, including an Industrial Commission order compelling discovery.
But that's not what's at issue here, obviously.
We are not saying that this claim should be dismissed solely because of a failure to comply with an order to compel discovery. We are contending that the prejudice to the appellants as a result partially of the failure to comply with that order was so significant to the defendants that the dismissal with prejudice was proper. I'd like to invite my co-counsel to address the remaining errors in the Court of Appeals majority opinion, and I thank you all for your time today.
Chief Justice Newby and Associate Justices, may it please the court. My name is Brian Cantley, and as my co-counsel stated, I'll be discussing finding of fact 25 and conclusion of law 5, which was treated as a finding of fact on appeal. In finding of fact 25, the Industrial Commission addressed the second prong of the Lee versus Roses test, which, similar to finding of fact 24, detailed an additional manner in which the plaintiff's delay caused prejudice to the defendants in this case. Specifically, what the commission found is that the defendants had borne substantial monetary expenses as a result of the plaintiff's delay, as they were, among other things, forced to maintain an open file and prepare and travel for anticipated litigation. The majority primarily took issue with this finding because the record did not contain evidence as to the precise amount of money or time spent, how far the defendants traveled, or how often they traveled. The majority stated that we do not assume mere motions, orders, correspondence, or hearing transcripts can show prejudice.
Is there any evidence that any travel occurred as the result of the plaintiff's various activities or lack thereof?
It can be inferred from the evidence, Your Honor, and similar to the Lentz case, the record contains motions and correspondence and pleadings which by inference show that the defendants did expend considerable time and effort defending the plaintiff's claim, including
in the Lentz case, at least if I read it correctly, and again, this is not my area of expertise and I'm happy to be corrected, but it appeared that at least twice in the Lentz case, the defendant showed up for a hearing with witnesses present and presumably did the preparation necessary to examine witnesses, and then the plaintiff failed to appear. Did anything like that happen here?
No, Your Honor, it didn't, but the defendants did attend a hearing on a motion to dismiss. And while the procedural history of the claim may have been different, what we really gleaned from the Lentz case is that essentially what the majority did here is say that there has to be some evidence of the precise amount of time or money spent by the defendants. And they cited to the Lentz case to support that position. However, if you look at the Lentz record,
is it your argument that preparing for and appearing at a motion to dismiss for failure to prosecute by itself is enough expense to justify allowing a motion to dismiss for failure to prosecute?
no, Your Honor, that's not our position. Our position is.
I wanted to be sure. Okay, thank you.
Thank you, Your Honor. No, our position is that essentially, as I said, the majority looked to the record to determine whether there was some evidence of the precise amount of money or time spent by the defendants. And they cited to the Lentz case for the proposition that that type of evidence is required. However, if you look at the record in the Lentz case, there's no such evidence in the record. In fact, it was inferred in that opinion that it was evident in the record based on the record containing motions, correspondence, and pleadings that the defendants had expended considerable time and effort. And if you look at our record, we have a second set of discovery which defendants were required to serve as a result of the plaintiff's failure to respond to our first set of discovery requests, a motion for an order compelling her responses for her failure to respond, as well as multiple correspondence with the plaintiff detailing her obligation to respond and the insufficiencies in her responses, as well as, in addition to all that, a motion to dismiss for failure to prosecute. So, as with the Lentz case, this evidence supports the commission's finding that the defendants had borne substantial monetary expenses as a result of the plaintiff's delay.
Is the inference that you say can be gleaned from the evidence enough to support that vivid adjective substantial?
It is, Your Honor, and the reason is that all of this was necessitated by the plaintiff's delay, and this is not, something that's normal in the normal course of a progression of a claim on the merits. And I think the important thing to remember here is that the commission's determination of what is substantial is a factual finding, and that's their inherent authority is to review the record before them and determine whether there's any competent evidence to support that finding.
While there is some administrative deference to be paid to an agency such as the Industrial Commission, to what extent do you say that a body such as the commission is allowed to be able to extrapolate from the evidence without there being actual figures to be able to give a depiction such as substantial? And where should we draw the line as a court in terms of something like that?
Well, I don't know that there's necessarily a line to draw, but I think what is required is that this court uphold the standard of review that's been consistently articulated by this court, which is that if there's any competent evidence in the record to support the finding, that it has to stand. And if you look at, again, at the Lentz case, it doesn't stand for what the majority says it stands for. It simply states that you can infer from the evidence whether there was considerable or substantial time or resources expended. And as Judge Dillon observed, there is evidence in our record of substantial time and effort expended here. And again, that's a discretionary matter that's within the full commission's discretion to determine.
Let me ask you a quick question about the full commission's opinion. And it's my understanding that the dissenting opinion would have the order vacated and remanded for further proceedings. Do you contend that if that order is vacated, that there would be some of it left standing?
Yes, Your Honor. As my co-counsel stated, our reading of that that mandate, if it were vacated and remanded to the full commission, was what Judge Dillon's directive was for the full commission to consider all the findings that, in his opinion, were supported by competent evidence, and in their discretion determine whether a dismissal was still appropriate. And he specifically noted that a dismissal would still be appropriate upon consideration of the supported findings.
Well, my understanding of the term vacate is that when an order or opinion below is vacated, that it goes away. And so I'm wondering, do you have any authority for the fact that it might mean something else that you and your co-counsel have argued?
I don't have any specific authority, Your Honor, but I'm really just basing that off of a reading of Judge Dillon's opinion. And he goes into pretty significant detail on what his mandate would be. And the full commission does have discretion under the Industrial Commission rules to take further evidence if they so choose to do. So I think that's a matter that would be within the discretion of the full commission.
Okay, thank you.
Do quickly,
You're well within your rebuttal time.
I see that, Your Honor. I think I will reserve the remainder of my time for rebuttal, and during that time, I'll address conclusion of all five. Thank you, Your Honor.
Thank you. We'll hear from the appellee.
Thank you, Mr. Chief Justice, Associate Justices of the Supreme Court of North Carolina. My name is Michael Burdix, and I represent Pamela Lauziere in this workers' compensation case. We have before you a simple question. Can a pro se plaintiff be thrown out of court within 2 years of her date of injury? The answer is no. At the outset, I should mention an issue that was discussed at some length by opposing counsel, and that is, what exactly is the dispute here? And I think we should be 100% clear that neither the majority nor the dissent agreed with the full commission. Neither voted to affirm the dismissal with prejudice of this claim. Defendants are arguing for a form of relief, the affirmance of the dismissal with prejudice that is beyond what either the majority or the dissent voted to do, which is inconsistent with the North Carolina rules of appellate procedure. That aside, let us look.
Well, just very, very quickly, how would, this is the same question I asked Ms. Ladeka, how would you explain the difference between what the majority would do on remand and what the dissenting opinion would have happen on remand?
Your Honor, the majority voted to allow this case to proceed on the merits, though they would, it appears to me at least, have preserved the option of a lesser sanction that would be monetary in nature, or some other sanction to be available to deal with the discovery issues that were outstanding. On the contrary, the dissent would have simply allowed the entire scope of defendant's Rule 616B motion to be reviewed by the full commission on remand, such that the same outcome could have been reached on alternate factual grounds.
Is it your understanding that if the dissenting judge's view were to prevail and the full commission opinion vacated, that there would be anything left standing from that opinion?
I don't believe so, Your Honor. I think that the full commission would have to consider the entire decision anew. And they could theoretically, as opposing counsel suggested, take additional evidence if they so desired on a defendant's Rule 41B motion.
Okay, thanks. I'm sorry if I threw you off of your train of thought. So continue, please.
Not at all, Your Honor. And actually, this dovetails nicely with the subject. The rules that govern this question is Rule 616B of the North Carolina Industrial Commission Rule and the companion rule of the North Carolina Rules of Civil Procedure, Rule 41B. Both essentially say the same thing as is applicable here. The question is, did the plaintiff engage in a course of dilatory conduct that would unduly delay the prosecution of the claim, or did plaintiff violate a court order? And the particular portion of Rule 41B or 616B, as the case may be, that was applied to dismiss plaintiff's claim was the failure to prosecute provision. That is not an issue that has come before this court before. Although this court has looked to Rule 41B and affirmed dismissal in the Daniels versus Montgomery case for a plaintiff who violated a court order, the issue of failure to prosecute hasn't come here. And so I should start first by discussing the legal standard applicable. The defendants assume that Lee versus Roses is the correct legal standard. Lee versus Roses is a lower court precedent. It has no precedential authority in this courtroom. And so therefore, I think we should look first to the federal courts, which is what this court has done in the Daniels versus Montgomery case.
Before you do that, it appears to me that the Court of Appeals has uniformly applied the Lee standard without the issue ever having reached here. Are you suggesting that there's some other standard that's appropriate?
Your Honor, the Lee standard was originally drawn from federal jurisprudence. However, in the Fourth Circuit specifically, Atkinson versus Holder adds one additional prong to the three Lee prongs. It also, Atkinson versus Holder quotes the standard as the plaintiff's degree of professional responsibility, the amount of prejudice caused to the defendant, the presence of a drawn-out history of deliberately proceeding in a dilatory fashion, and 4, the effectiveness of sanctions less drastic than dismissal. It's a small distinction, but I think it's an important distinction. Lee doesn't look to this issue of is the plaintiff pro se.
Of the four things that you just enumerated for us, to what extent, if any, are those four things not encompassed within the what we've been calling the Lee standard?
The issue that is not really encompassed in the Lee standard as written is the personal responsibility of the plaintiff. And that is a subject that Atkinson addresses, and also that I think is pretty important. Is the plaintiff pro se or not? Did the plaintiff themselves?
Is that not to some extent at least subsumed within the issue of whether a lesser sanction would be appropriate?
To some degree. Though it does not appear to be an issue that at all played into the full commission's decision here, suggesting that the Lee standard didn't really tell them to look at Ms. Lauziere's personal responsibility and whether she was unfamiliar with the legal system, as all of the events that took place here occurred prior to her being represented by counsel. The issue, of course, is that in workers' compensation cases, this court is recognized in cases such as Vernon versus Steve L. Mabe that the pro se status of a plaintiff is important, that the Industrial Commission has something of a paternalistic role in protecting pro se plaintiffs and not treating them with the harshness that a counsel or an attorney at law might be treated for the same conduct. That didn't happen here. Ms. Lauziere was treated fairly harshly with, frankly, the harshest possible sanction without prior warning. And she was under no prior understanding that she was in violation of any rules. That's
Are you saying then that a pro se plaintiff has automatic and inherent insulation from the operation of the rules?
Your Honor, I believe that a pro se plaintiff should be given a little bit of consideration. That's all. Doesn't mean that a plaintiff a pro se plaintiff can ignore the rules, but maybe a pro se plaintiff should receive a warning first before receiving the ultimate possible sanction.
Isn't that within the deference of the agency?
To some
The
degree, Your
discretion of
Honor.
the agency?
To some degree, Your Honor, that is correct. I would agree very much that the agency should have a significant amount of deference on that subject. Nonetheless,
how does a reviewing court then determine whether an agency gives sufficient but not too much latitude to a pro se? If we're going to create a standard that says that the rules for pro se litigants are different than they are for represented litigants, how does a reviewing court enforce the standard that you enunciate?
Your Honor, the answer is, did the full commission make findings on that subject to show that it engaged in a reasoned process for considering the plaintiff's pro se status? That's all. We have no findings on that subject at all here. So I point out that this is a relatively minor distinction between the Lee versus the Atkinson standard, but given that this court has never previously considered this issue, I do believe it is important for this issue to be considered now. So I'm going to turn next to the issue of prejudice. That is what the majority opinion and the dissent focused for the substantial part of their text on. And it is what opposing counsel spent a substantial amount of time on as well. And specifically, I want to refer the court to record pages 157 through 159 of the record on appeal, because this is critical. These pages are the pro se plaintiff's discovery responses to defendant's second set of discovery. And they make very clear that some of the statements defendants are making aren't really true. First and foremost, Ms. Lauziere went through each of defendant's 4 interrogatories in their second set of discovery, and she answered all of them. You can see that on pages 157 and 158. Moreover, and this goes to Justice Hudson's question, Ms. Lauziere provided the names of her doctors. She provided the names of her doctors. They're right here. Reading directly from the bottom of page 157. To question number 2, regarding which doctors she saw. Dr. Hart, Dr. Clary, Dr. Nelson, Dr. Rich, Dr. Niedenthal, Dr. Martha Harris, Dr. Wilson. They're all listed there. The defendants had absolute ability using NC Genstat 9725.6 C1 to be able to go make medical records requests to get those doctors. They were not prejudiced as to their ability to investigate this claim in the least.
So which of these doctors treated her prior conditions?
Yes, Your Honor. And she specifically addresses this in her answer to...
My question is, with number 2, which of those doctors treated her prior conditions?
Dr. Wilson, surgery on left knee in 2012. In number 3, and I'm referring specifically, Your Honor, to record page 158. She speaks to the accident on 6/18/15, which is one of her prior issues. She says Dr. Niedenthal and Dr. Odom. She refers to her jaw issues. She says she saw Dr. Clary and Dr. Hart of Carolina Family Practice. She answered the defendant's questions, Your Honor.
So the only thing wasn't there a 2002 claim?
Your Honor, there may have been a 2002 claim. I believe that is correct.
And which physicians treated her in the 2002 claim?
I don't think Ms. Lauziere clarified exactly which ones she saw for that, but she did answer the questions that were asked of her, is my point. The defendants actually addressed that factor too, Your Honor, in page 160. That is the email that Ms. Ledeka sent to Ms. Lauziere on June 22nd of 2016, where she acknowledges that she'd been provided the names of the doctors, but was just asking for the medical records. That's all she asked for. She didn't say, I think your answers are incomplete because you didn't name all your doctors. She said, you need to get me the records.
So let's get back to the majority and dissenting opinions.
Yes, Your Honor.
On precisely what point do they diverge?
They diverge on the question of whether defendants suffered prejudice. That is it. The issue of whether
diverged on whether certain findings of facts were supported by the record.
Yes, Your Honor, specifically the findings on prejudice. Findings of fact 24 and 25 specifically are the findings on prejudice. The thing that they seemed to agree most on is conclusion of law 5, having to do with whether lesser sanctions could be properly considered. They agreed that the full commission did not give proper consideration to the possibility of lesser sanctions and that there was no evidence that lesser sanctions wouldn't have worked.
So as you look at our standard of review where we are here on a dissent and the question becomes, you know, do we follow the majority opinion or the dissenting opinion? What aspect of the disagreement do you think is supportive most of your position and why?
Yes, Your Honor. Chief Justice Newby, the majority has the more cogent analysis on the presence of evidence on the findings of prejudice. There were 3 kinds of prejudice that the full commission identified. 3 kinds. The first, investigative prejudice. The second, monetary prejudice. And the third, prejudice as to the defendant's potential right to direct medical care. This is the primary area of disagreement, Your Honor.
Let me jump in here for a second and ask you about the findings. Under the majority opinion, is it your position or understanding that the full commission opinion would remain intact on remand except for those specific findings, 24 and 25, and the conclusion about dismissal?
Your Honor, I think ultimately the fact that the whole decision was reversed and remanded would probably throw everything into play in practice. My reading of the Court of Appeals decision is it did not provide a mandate that was narrower than that. And if they had, then perhaps the answer is different from what I just gave you. But
so typically, if there were a reversal of a full commission opinion and remand for the proceedings, the commission could take additional evidence and enter a whole new order, regardless of how many findings were challenged when it came up before.
That is correct, Your Honor.
Okay, good. I just wanted
correct.
to be clear about that. Let me ask you, this is a slightly unrelated question, but it was about what you were talking about earlier about the responses to discovery and prejudice.
Yes.
And I may have missed this, and maybe it happened in the record and I didn't see it, but did the defendants make any attempt to take the plaintiff's deposition after being dissatisfied with her answers to the interrogatories?
No, Your Honor, there is no evidence of that. There is no evidence.
Isn't that available as an option under the statute and rules to ask the commission if they can?
That is an option that is certainly available. It is not a course of standard practice in workers' compensation to take a pre-hearing discovery deposition. Certainly available. We, from time to time, do take pre-hearing discovery depositions, but unlike in civil court, that is not a standard course that happens in 95% of the claims.
Well, would you think that in a case where it's the plaintiff herself who is giving answers to discovery that the defendant finds inadequate, that the commission might entertain in order to allow her deposition to go forward?
Absolutely. Absolutely, Your Honor. The tools that are available to answer discovery in workers' compensation cases, as set forth in Rule 605 of the North Carolina Industrial Commission rules, they're fairly broad in terms of what parties are able to ask the commission to permit. Right. So that is not a tool that is outside the toolbox, so to speak.
Okay, that was what I thought. I know it's not, you don't do it in every case like in civil court, but it is a tool that's available if you need it for reasons you can explain.
Yes, Your Honor.
If I may ask you a question before you move on, just in response to Chief Justice Newby's question about whether we follow the majority or the dissenting opinion, my question to you is whether, in your view, Rule 28 of the North Carolina Rules of Appellate Procedure gives you, as the appellee, the ability to support the judgment of the majority on any grounds, whether or not it's in the dissent?
Your Honor, I would think the answer is yes. I would agree very much with that. Thank you very much, Your Honor. Going to the question of the variety of prejudice that have been found by the full commission and the difference between the majority and the dissenting opinion, the question of investigative prejudice, I think, has already been addressed at some length. The defendants had the names of the providers, they had the answers to discovery, they could have investigated and they did not. Second, the question of the right to direct medical care. There is a disagreement here between the majority and the dissent on whether that can constitute prejudice in a denied claim. It is black letter law stated from this court that the defendants do not have a right to direct medical care in a denied claim. They do not. This court said that in Schofield versus Great Atlantic and Pacific Tea Company. It said it most recently in Wilkes versus the city of Greenville. This is a principle that has been around for decades. And this is a denied claim. And so fundamentally, the majority cites to the Yingling case, which is a Court of Appeals decision, which recognizes that defendants have no right to direct medical care here, and therefore they cannot, on the one hand, deny the claim, and out of the other side of their mouth, cry prejudice because they don't have a right or can't exercise a right that they don't even have. The dissent comes to a different interpretation, saying that if the defendants had more information they did not seek, because they didn't request the medical records, that the defendants might have reversed their position. That is no more than potential or inchoate prejudice. That's not prejudice sufficient to warrant a dismissal without or with prejudice. The ultimate sanction that is available. A party can always claim that if they had more information or if the other party had behaved differently, that they also would have done things differently.
Counsel, was there a motion to compel here that was granted?
There was a motion to compel that was filed, I believe, April 22nd. The defendant sought to have plaintiff answer their second set of discovery. On April 28th, 2016, pages 75 and 76 of the record on appeal, the Deputy Commissioner Bedore required plaintiff to answer. Not answer fully, just answer. And the plaintiff did.
Let me be clear. You think there's a difference between answer and answer fully?
Your Honor, the defendants actually asked for language meaning answer fully without objection. Without objection is a little bit different than answer. And the deputy specifically removed that extra language.
I mean, what's the point? The point is to get an honest answer to the deposition or to the questions and to get a full answer. I mean, an honest and full disclosure. I don't see how you're saying that somehow that's draconian or something.
I'm not arguing it's draconian, Your Honor. Chief Justice Newby, I'm simply referring to pages 157 through 159 of the record on appeal, where plaintiff did provide answers to each of the four questions.
Well,
and those answers.
So we don't reweigh whether those answers are adequate or not. That's up to ultimately the decision maker below. And we ask the question, is there sufficient evidence in the record to support their findings and the conclusion? So the question I'm asking, I'm hearing your argument to really attack all of the bases of the commission when I'm not sure that the majority opinion goes that far. It seems to me that the majority is questioning whether there are adequate facts, as you've indicated, under the prejudice or findings of fact 24 and 25. Isn't that the precise issue before us?
I would agree, Your Honor. I'm simply pointing out that there were other problems as well in the full commission's decision, problems that the majority and the dissent never really got to. But to argue that the plaintiff here, which, and this goes to some of the prejudice issues, arguing that the plaintiff didn't give defendants the information they needed and therefore prejudice defendants' investigation isn't really true. We do get to go and look to see whether there's competent evidence to support that finding. And the evidence in the record shows that the plaintiff didn't prejudice defendants' ability to investigate the claim. And therefore, the majority is more correct on that point than the dissent.
But that's not what the majority said, correct?
I think the majority did agree that there was not demonstrated investigative prejudice. The defendants said we've been prejudiced. The majority said there's no evidence to support that finding. It does go to whether there is evidence to undergird the full commission's finding of fact 24 that there was investigative prejudice. No, there was not. Which I think brings us next to the question of whether defendants suffered monetary prejudice. And the answer again is no. Defendants have pointed to, and that the full commission as well pointed to, a mediation, which happens because of mandatory mediation in workers' compensation claims, pretty much every case. That's not prejudice, because if travel to a mediation is prejudice, then prejudice is present in literally every single claim. And a test which is always met isn't a test. They also point to apparently hearings that were traveled to. And I think this goes to Justice Irvin's question earlier. Defendants only traveled to one hearing in this claim. It was the hearing on their motion to dismiss. In that regard, the full commission found, I guess, that the defendants are able to generate their own prejudice. They can file a motion to dismiss and then prove their motion to dismiss by virtue of going to that hearing. That's bootstrapping, and that doesn't make any sense. Again, that would be present in manufacturable in literally every single claim. And therefore, that's not adequate prejudice. And so we ask, what is present here that is not present in a normal workers' comp case? And there's nothing. There's no evidence of anything significant exceeding the norm. In contrast, of course, to Lentz, where you have multiple hearings that the plaintiffs get.
Mr. Burdick, when I discussed this question with your colleagues, I would think my attention was also directed to items of correspondence, detailed items of correspondence and a motion to compel, in addition to the other items that you've discussed. What's your response to that argument?
Your Honor, those items are also present in pretty much every case. In fact, they're called for in the Industrial Commission rules. Industrial Commission Rule 605 specifically requires informal communications between the parties on discovery issues prior to involving the Industrial Commission. That's normal litigation expense. It's nothing outside the ordinary. It's present in all of my claims. And again, if that's adequate prejudice, and it's present in every case, then prejudice isn't actually a part of the test, because it would always be present. A party cannot cry prejudice by pointing to ordinary litigation expenses, as they are doing here. Because the defendants aren't able to identify anything out of the ordinary to warrant applying the ultimate possible sanction in a workers' compensation claim, they cannot establish that, and the majority is correct. The dissent's focus on this issue of itemization really misses that point. Lentz is relevant because it shows that you have to have significant extraordinary expense, things like hearings that the defendants prepared for and went to that couldn't go forward because the plaintiff didn't show.
The commission sees more workers' compensation matters than this court does. Why should we not give deference to the administrative body in terms of the many cases that they would see that would contain these kinds of issues, and give deference to the fact that if it feels as though dismissal with prejudice is warranted here in light of these kinds of facts, that we should not allow them to harmonize that with the kinds of cases that also show those kinds of elements?
Justice Morgan, if we're going to give the commission some deference on the subject, let's look to the actual precedent applying Rule 41B or 616B to dismissal with prejudice for failure to prosecute. I've cited them in my brief. Cases like Harvey versus Cedar Creek, where the plaintiff did far worse than occurred here, and it was an abuse of discretion to dismiss her claim. Or Matthews versus City of Charlotte, where again, multiple hearings were missed, and it was an abuse of discretion to dismiss the plaintiff's claim. This case, Lauziere versus Stanley Martin Communities, is sui generis. There's nothing else like it. the defendants have not been ever at any stage of this process able to identify any precedent where a sanction this severe was assessed for so little.
Let me just jump in real quick and ask you, isn't the extent of the court's deference to the commission pretty much spelled out in 9786, where it specifies that the award is conclusive as to the facts, and and then the case law has developed around that to explain what the standard of review of those findings is?
Yes, Your Honor. And what we have are really three different standards of review that apply to different aspects of this decision. One, the facts are supported, or the findings of fact of the commission, i.e. what happened. That's reviewed on any competent evidence standard. Whether those facts support a legal conclusion, that's a de novo standard. And then the choice of sanction, that is an abuse of discretion standard. I would believe that a large portion of what we're dealing with here is going to be a de novo standard. The question of whether these facts equal the prong set forth in either Lee versus Roses or Atkinson versus Holder is the application of law to facts. Those are conclusions of law, and those are going to be reviewed de novo under well-established case law from this court.
And as I understood the Court of Appeals majority, they're basically saying that findings 24 and 25, even if they are supported, don't give enough detail to support the conclusion that dismissal is appropriate.
That is correct, Your Honor. And I would add, they evaluate this under the relatively deferential any competent evidence standard. I think they could go further and say that these are really conclusions of law, and that as a result, they shouldn't be given the level of deference they were, because they do apply the application of judgments to facts. Did the plaintiff's conduct actually constitute delay? That's not really a factual finding. What plaintiff's conduct is a factual finding, but whether that constitutes the kind of delay necessary to activate the ultimate sanction, that's a conclusion of law. Then the decision of how to sanction the plaintiff if Rule 41B is activated, that's an abuse of discretion consideration. In closing, I will point to some, I think, fairly important precedent from this court. Harrell versus Harriet and Henderson Yarns. It's the provision that the Workers' Compensation Act is intended to be liberally construed in favor of compensability, such that benefits are not to be denied upon technical, narrow, or strict interpretation. That is well-established precedent of this court. And there is no more narrow, technical, or strict interpretation of the act than to throw a plaintiff out of court, not giving her a hearing on the merits, but because she took too long, and not giving her a warning first. No due process, no indication that she was in mortal peril of her claim being denied and ended. Just out of the blue, she's thrown out of court. That is grossly inconsistent with this precedent. Thank you, Your Honors.
Thank you, Counsel. Rebuttal.
Thank you, Chief Justice Newby. First, Justice Hudson, I do want to address your line of questioning on what would happen if the order was vacated and remanded. If you look at, I would direct your attention to Rule 704 of the Industrial Commission Rules, which addresses how claims are to be handled on remand from the appellate courts. And specifically, what would happen is the parties would file a statement setting forth their position with regard to whether additional evidence is required to be taken or not. And then the commission, within its own discretion, would determine whether or not to take additional evidence and then consider any issues that are still before it in order to comply with the court's order. So in this case, Your Honor, essentially, if you affirm on the basis and you vacate and remand, as Judge Dillon would have, those issues would all correctly be before the Industrial Commission, whether or not to, as he stated, dismiss the claim with the findings that were supported by competent evidence, or to not dismiss the claim, or assess lesser sanctions, or let the claim proceed on the merits. So that is what would happen there.
Thank you for that. When I was in practice, we used to refer to the Rule 704 process as the remand black hole.
Yes, Your Honor.
You never know exactly what's going to happen there.
A couple other things I do want to quickly address. A lot was made of the commission's the requirement that they protect pro se claimants. And the line of cases that are cited to by the plaintiff in his brief, or her brief, I should say, really deal with a very narrow issue of the Industrial Commission acting in its judicial capacity to review and approve settlement agreements. A lot of those cases had to do with pro se plaintiffs who were giving up their right to additional indemnity benefits and accepted payment for a scheduled injury when they could have been entitled to additional compensation. And that is under 9717 that the Industrial Commission is required to, in its judicial capacity, protect the interests of pro se litigants. But it is not, as Chief Justice Newby suggested, not an excuse for the plaintiff to not comply with the rules of discovery. And lastly, I do want to quickly address the contention that the defendants had the option under 9725.6 to obtain plaintiff's medical records. As my co-counsel briefly got into, we did not have a full picture of the plaintiff's medical treatment as a result of her responses to discovery. She acknowledged that she forgot who her 2002 injury doctors were, and she acknowledged that she forgot who her attorney in the 2012 workers' comp claim was. So there's no way for us to know for certain.
Thank you, counsel.
Thank you, Your Honor.
Your time has expired.
Thank you.
Madam Clerk, I think we'll take a 45-minute recess.
Oh yes, oh yes, oh yes, the Supreme Court of North Carolina will be in recess for 45 minutes. God save the state and this honorable court. Thanks, counsel.